Welcome to the LivXplore Podcast. If you like what you hear, please hit like and subscribe. Welcome, everyone. I'm Sean Payne, co-host of the LivXplore Podcast. Today I have with me my co-host.
I'm Isaiah Chass.
And we have another great podcast for you. We have Kevin O'Connor, attorney at law, and we're going to talk about estate planning today. Kevin, thank you very much for joining us.
Happy to be here. Thank you.
So, tell us a little bit about you. How long have you been in estate planning? Why'd you get into it that way?
Sure. Yes. Yeah. Let's see. So I've been an estate planner for 9 years now, and my first career was as a medical social worker.
Okay.
And that was interesting, and there's a lot of things I liked about it, but there's I wanted a new challenge, I suppose, and I also wanted to sort of build on what I had, because I worked at a hospice, actually, so it was sort of a little bit similar, wills and trusts and death and stuff.
Right. Did you see like a need for estate planning from that, or people maybe have taken advantage of, or things of that nature that way?
Yeah. It's interesting. I remember one time there was this couple where at that point I was a hospice social worker. The wife was dying. They had their house in joint tenancy. We can touch on this later. And I remember thinking, ooh, that's not so good. And I wanted to give them some advice, but I was a medical social worker. I wasn't supposed to be acting as an attorney, and
Right.
There was a lot going on, and I tried to share information with them. They said, oh, we're just going to go with what the realtor said. We're going to keep it in joint tenancy. I can tell you more about that.
Yeah.
Don't
Go with what the realtor said in that situation. We're not supposed to give that advice.
Yes,
Yeah. So, very interesting. Well, so let's jump into it. Can you explain like what estate planning is and
Sure.
and why it's important for homeowners that way?
Yes. So estate planning, it's planning for the final chapter, preparing for that and getting your affairs in order. You get to, at the beginning of life, you don't have a lot of say. But at the end of life, if you do estate planning, you can have some say. You can have some say as to what happens in the event of incapacity or diminished capacity, preparing for that harder aspect of life. And then also you can have some say as to, where your assets go upon your death. And then if you're a homeowner, if you own real estate, it's especially important because you have this big asset and you want to make sure that that's transferred in a way that benefits your beneficiaries as much as possible. And then also in the event of incapacity or diminished capacity, just needing help with things. A lot of times people don't, in their last few years of life, they don't file taxes. Maybe they're not incapacitated, but you just want to make preparation for that, and making sure that this big asset is managed for your benefit in that sensitive period is something that you do in estate planning.
Okay. Yeah. Sure. And what's usually the instrument that you use?
Sure.
Do you want to talk a little bit about that?
Yes. Yeah. Typically what you're doing more than 9 times out of 10 is a revocable living trust.
Okay.
And the way a revocable living trust works is you're able to, you're the trustee, or you and your spouse are the trustees, and then you name a successor trustee. And then it sort of functions like a will upon death, where the successor trustee is like an executor with a will. And so your successor trustee can distribute your assets as you wish. And that's particularly important when it comes to a house,
right,
or other real property.
And why is that like the preferred method for transferring it? This is so important because so often people say, well, I have a will.
Right.
And they think that they've done what they need to do, and can you go into a little bit about that? While
Sure.
In terms of real property,
Yes,
a revocable trust is probably the better method that way. So.
Correct. Yes. If you have a will has to go through probate, and probate is very expensive.
Right.
If you have, say, $1 million worth of assets, which if you're a homeowner is not hard to get there. Then you have, if you're doing probate, attorney's fees are $23,000, and there's other court fees, and it's also a time-consuming process. It's a public process. A court is involved, and most people seek to avoid that. Whereas if you do a revocable living trust, you can have your assets, including your house, pass outside of probate. Much less expensive, private, and yeah.
Right.
Besides a revocable living trust, what are some of the other methods that people might be able to use to transfer ownership upon death?
Sure. Yes. Yeah. One of the things I touched on a little bit is joint tenancy. And with joint tenancy, what happens there is that, let's say you have two owners of a property. When one owner dies, the surviving ownership has something called right of survivorship. They own the 100% of the property at that point. And another way that married couples can own property, which is advantageous over joint tenancy with right of survivorship, is community property with right of survivorship. So it's not as good as a trust, but it's that's another way that people can pass property. But then in both of those instances, yes, the right of survivorship is helpful. When one person dies, then the other takes it. But then what happens when they're both gone? And that's one of the advantages of a revocable living trust.
And also, I'm kind of jumping ahead a little bit here, but I think can you explain a little bit? So, let's say you're a new individual couple, whoever the entity may be, and you purchase a property earlier on in your life. You may want to hold proper title to that differently as you accumulate wealth and things of that nature. Isn't that the case in terms of joint tenancy versus community property that way? Can't there be some benefits, pluses and minuses, and liabilities that way?
Let's see. I know just the biggest difference that I like to underscore between community property with right of survivorship and joint tenancy with right of survivorship is there's a step up in basis, and that is how step up in basis works. To explain that, you have to get into capital gains taxes. So with capital gains taxes, there's the IRS looks at what when you first acquired an investment, and they compare that to what you sold it for, and that's your capital gain. You get taxed on that. What you acquired it at, that's your basis. And then with when something is bequeathed, when you inherit something, you get a step up in basis. And what that means is that, say I bought a house, say I got a vacation home for $200,000. It's worth $1 million. I leave it to my son, and in my trust, he goes and sells it for $1 million after my death. There's a step up in basis. He doesn't get the new basis is $1 million as of the date of my death because he inherited it. And then with joint tenancy, the problem there is that when you have a couple, you only get, we have a married couple, you only get half a step up in basis. So with joint tenancy, say if a husband and wife holds property as joint tenants, then say the wife dies, then the husband gets 100% of the property. And if the husband wants to downsize, if he wants to, the memories are too painful, I want to move out of this house and get another one, he only gets a half step up in basis. Whereas with community property with right of survivorship, you get the full step up in basis upon the death of the spouse.
Okay.
That was the situation, earlier on I was talking about with the couple where they wanted to keep it in joint tenancy because that's what their realtor said, and that what does a social worker know?
Right.
Yeah.
Okay.
And I think it's important to note also that I sometimes you hear people that don't want the step up basis to be as high because there's higher property taxes sometimes.
Right.
But what a lot of people don't always factor in is that will be greatly outweighed by the capital gains tax you pay.
Yes, right, indeed. Yes, yeah. Yeah, it's tough because the taxes, there's, most people aren't dealing with estate taxes anymore because that, the exemption amount for estate taxes at the federal, there's no estate taxes in California. At the federal level, it's 13 million something, 26 something, or 27 million for a couple. But then, so most people don't have to think about that. But actually that's changing because on January 1st, 2026, it's going to go down to around 7 million. So that's going to impact a lot more people.
Right.
But still, for most people, that type of tax isn't a thing.
Sure.
But there's capital gains tax, there's property taxes. It kind of can make your head spin.
Right.
Between joint tenancy, community property, revocable living trusts, how do they compare in ease of cost, time, setting them up?
Sure, yes, yeah. The community property with right of survivorship, that is something where if you're a realtor and you're working with a married couple, be sure and tell them to, have it as, community property with right of survivorship as opposed to joint tenancy. It's just, very easy. You just take the property in that manner. And similarly with joint tenancy, it's real easy. You just take it in that manner. But a revocable living trust is more expensive. You're sitting down with an attorney doing your estate planning, and that's, a few $1,000s. But you save, particularly with something like real estate, you don't want to just be penny wise and pound foolish. It's kind of a tired old metaphor, but it's really true. It's just you're talking about $1 million, and then to save a few $1,000s, and then gamble. I think this will work. Not so good.
Right. Yeah. Yes. Yeah. And I think like a lot of people hear about like setting up a revocable trust. Maybe it sounds intimidating.
It does.
But I mean, it's not, like you said, it's a few $1,000s that way. It's well worth it. It's not a huge barrier to have one put together by an experienced attorney that way.
Correct.
So,
Yes.
And that way I say it like an experienced attorney, so someone doesn't go online and there's various services, and all of a sudden they realize it's not enforceable, it's not real, whatever.
Sure.
There's huge holes in it that way. So it's important to go to someone that actually knows what they're doing.
Yes,
So,
thank you for bringing that up. I was thinking of mentioning that. I know with LegalZoom, I was looking at their disclaimers, and on their commercials, they say, "Oh yeah, we got your back," and there's lawyers there on their commercials. We got this all figured out, and then on the disclaimer, you say, "I understand that I'm doing this myself. This is DIY estate planning."
Right.
And I know legal or Nolo Press. I think Nolo Press is really good overall.
Okay.
They offer books on legal matters, and they say doing your own estate plan is easy. Like, no, fight your parking ticket with Nolo Press and understand neighbor law with Nolo Press, but don't,
or maybe use it as a primer so you can talk to your attorney.
Indeed, absolutely. Yes.
About what estate planning is and a revocable trust, but
there's a lot of entities out there that are just trying to lure people in that understandably don't want to spend a few $1,000s. But
sure, could you go through so let's say you get a call from someone that wants to create a revocable trust. Can you just kind of go through the process right now and explain it so they can see that it's not as intimidating as what they may think?
Sure, yes. So when someone calls me, usually asking what you asked, that they need a revocable living trust, usually they need more than that. Usually there's sort of a big four of estate planning documents. There's the trust, and then there's a will. And actually, while the trust is the preferred method, you still want to have a will, a backup will, and it's called a pour-over will. And what the pour-over will does, it says any assets not controlled by the trust, anything that doesn't have a transfer on death designation, some account, or anything where you just slipped up, maybe a person refinanced, and they took their house out of the trust for the refinance and forgot to put it back in because they were so busy. The pour-over will says any assets lingering out there, they are to be directed as per the terms of the trust. That's what the pour-over will does.
Oh, okay.
And then
that'd be personal items as well.
Correct. Anything. Well, actually, that brings up when you make a trust, one of the things that you do is you do a general assignment of property, and you say, if I were single, I would say, I, Kevin O'Connor, I have this general property assignment. I assign all of my property, everything from my sofa, my silverware, my car, everything to Kevin O'Connor, trustee of the Kevin O'Connor Revocable Living Trust. And so everything is owned by the trust. You do that with, you do a new deed. If you own a home, you say, I, Kevin O'Connor, grant to Kevin O'Connor, trustee of the Kevin O'Connor Trust, this property. So everything it's owned. Sometimes people say it's owned by the trust, but it's really owned by you as the trustee of the trust. And then, as I touched on earlier, you name a successor trustee. And then when you can no longer be trustee, then the successor trustee takes over, either managing your assets for your benefit or distributing them upon your death.
Okay.
And then, so you're asking about setting things up. So then, I have people do a questionnaire before the first meeting. We meet a first time, we review the questionnaire. I have more questions for them, find out what their estate planning goals are. We meet a second time and we have a review of drafts that I put together between the first and the second appointments. And then we meet a third time. And typically in that second meeting, we're making refinements and people can get a better handle on some of the legalese. And I almost always have more questions and people have more questions as well. Those meetings are an hour and a half, those first two, and then the last one we're executing the documents, and that's about an hour. And then I follow up with, once the trust has been executed, I'll, with the county, I'll send them the deed that we'll have signed in that signing appointment. Yeah.
Right.
Yeah.
Well, we spoke a lot about holding title for married couples.
Yes, yes.
What are some of the differences, or I guess options if you're single or you're just a one individual, or maybe you don't want to hold it with your spouse?
Someone else, yes, yeah. Let's see. As an individual, there again, you'd want to do a trust. I know there's another sort of DIY estate planning thing, the transfer on death deeds. I imagine you have some familiarity with those. A person, you can name a beneficiary, but you can't name a backup beneficiary. And there's also this thing where for a few years, the property after it has been inherited with a transfer on death deed, it's kind of in this legal limbo and you can't get title insurance. So if your beneficiary has difficulty holding on to the property, that could be a very big deal. So it's one of those sort of shortcut things that can lead to problems.
Right. Who are most of your clientele? Like just in terms of like age, when do people come to you usually?
Right. Yes. Yeah.
Yeah. I'm kind of curious that way.
Yes. So. Yeah. Let's see. So now, most of them are older. And I met with a 92-year-old the other day. I felt so young. It was kind of, I love meeting with people in their 90s. And so a lot of people, most people are older than me. Sometimes I meet with couples. It's less frequent. When I say a couple, I mean a younger couple. It's less frequent. It's important. I remember I was going to Empire College at night, and I didn't have my affairs in order yet. And my father was like, what? You have kids and you don't have anything, because you want to set up, one of the things that you do in a will is you say who would be proposed guardians for your kids if it was date night and things went very badly with your spouse. And so it's, a lot of couples don't do it. And I think, it's expensive having kids and you're busy as heck. I think that's a lot of it.
Right.
But you get some of that. And, let's see. And most of them, my slogan of my company is everyday people estate planning, trying to make it sort of less intimidating.
Right.
And so I don't work so much with high net worth clients myself.
Right. Yeah, it's kind of like something we try to like convince our clients. It's something that I've always struggled with. Is like you buy a piece of real property. It's like, well, you should create a irrevocable trust and just
a revocable trust.
Revocable trust and getting them to do it is just that doesn't happen,
Yes,
and there's obviously a lot of benefits to do it that way. So
it's so procrastinated. I think it's the most procrastinated activity in the sphere of human activity.
Right.
It's just one of those things that one should do. And it's one of the things that's nice about my job is I just see the relief that people have. They're always kind of bummed at themselves, and they shouldn't be that it took them so long to get into the office. But it's nice to have them have that relief at the end.
And another thing too is that, like, let's say they wanted to change beneficiaries or something of that nature.
Yes.
Nothing's set in stone again, that they can make those changes down the road that way.
Correct.
Can you go into that a little bit?
Sure, yes. Yeah, revocable means changeable. You can revoke it, you can change it. So it's handy that way. I know when you have an irrevocable trust, that actually doesn't mean it's unchangeable. It means you have to go to court to change it. It could indeed be unchangeable, but it's surprising how much monkeying can happen with irrevocable trusts.
Okay.
But they're very much
someone
updatable.
Choose that option.
Yes, it's it's not so common. It's more high net worth clients that do that, and I haven't really studied that area so much. It's basically, well, there is one area in which I work that's special needs trusts.
Sure.
And if a person, let's say, if a person becomes disabled because of a very bad car accident, and then they get a large settlement, and that person wants to take advantage of, I don't mean in any negative way, they want to be able to utilize, services like Medi-Cal and such, they can create an irrevocable special needs trust, and they put their assets into the irrevocable special needs trust, and they sort of don't have access to it anymore. Mm-hmm. They name a trustee that is in charge of it, and they're the beneficiary, but it's not really theirs, and so they can take it, they can receive those government benefits.
So that income doesn't count towards, or
correct.
those assets don't count towards their
Exactly. Yeah, that's one instance. Yeah.
I see. Okay. Very interesting. Why don't we jump into Prop 19?
Mm-hmm. Yes.
Can you explain what Prop 19 is and how it represents a significant change?
Sure.
That way.
Yeah. Let's see. So first, I think it's necessary to talk about Prop 13, and that's something that I imagine most listeners are aware of. But just to review, that keeps a low property tax basis. So you get a property. When Proposition 13, when California voters approved that in 1978, the thinking was, with properties appreciating so much in value in California, you're going to have, an older person on a fixed income getting priced out of their home because they can't pay the property taxes anymore. Mm-hmm. And then you had Proposition 58 that came along later, and I imagine the advertisements for that look something like, okay, so we're not kicking grandma out of her home, but what about the disabled adult daughter who was living with her, who now the property tax jumps up upon her death? So Proposition 58, that allowed children to inherit that low property tax basis. And so I think when voters approved that, they were more anticipating, the adult disabled daughter not getting kicked out of the home, who was, that was her primary residence. But you had, shopping malls with, being transferred, and apartment complexes and multiple homes, and it just made a lot less sense from a public policy perspective. Right. And so along came Proposition 19, and then with Proposition 19, it had kind of a rough start. I think it was written kind of hastily, and so there's been some criticisms of it in that regard. But the basic idea is that an adult child, or if an adult child is predeceasing and there's a grandchild, let's just say the adult child can inherit only the primary residence of the person who had the property. And it has to be the primary residence of the adult child. You can't receive it as a rental. And so that's the big change. And then that's sort of the vinegar of Proposition 19, where that that inheritable low property tax basis for multiple properties on the way can only be for the primary residence. But then the honey of Proposition 19 is if you're over 55, you can transfer your low property tax basis up to 3 times. If you're disabled or a wildfire victim, you can transfer your low property tax basis to another.
Right. I remember it created a lot of confusion within the agricultural community.
Yes.
And farmers and things of that nature.
Right. But that worked out, is my understanding.
Yeah, I think it did. But at the time, it was like, what's the primary residence? And then, things of that nature was certainly concerned. So, I'm glad that it didn't hurt the agricultural properties that way.
Yes.
So, is there any other topics that you think that are coming down the road that's going to affect estate planning in the near future? Or how do you see estate planning evolving?
Good question. Let's see. Well, a big thing is the presumptive change in the estate tax exemption. So now, as I said earlier, it's $13 million for an individual, but it's going to be roughly halved.
Right.
And so that's just going to impact a lot more people. And then with the way estate planners think, we want to prepare. If someone's anywhere near that threshold, we want to make sure that they're not going to get hit with estate taxes if we can avoid it.
Sure. Some of the things that we're seeing is it seems like some people are now, if they're close to that threshold or above, they're starting to transfer their wealth while they're still alive to the younger generations
Yes,
that way.
yeah.
Is that something that is that kind of a common route that you're seeing?
I don't work with high net worth.
Right,
So
okay.
I don't. If you're hearing that, I believe it. Absolutely. Yeah. People are definitely making preparations,
Right.
and it's possible that it'll stay high, but I don't. That doesn't. And I think there'd have to be bipartisan agreement in Congress for there to be any shift, other than for it to go down.
Probably not
to
going to find that momentum.
No, I don't think so.
Yeah. So.
Do you have any horror stories or examples of situations that for those listeners that might still be kicking down the road to help them get in gear and realize that they should start playing this?
Yeah. That's a good question. There's sometimes it's hard, but I'll talk to people where they have diminishing capacity and they know what they want, and I want to help them, and things are getting close. Maybe they're close to the end of their life, or maybe they don't have a terminal prognosis, but they're just having difficulty cognitively, and it's hard for them to do estate planning. I have to be careful.
Sure.
Yeah, and so sometimes it's like, sorry, I know you want to do this change, and I can see the benefits to it, but gosh, I'm not hearing that you meet the minimum standards for Yeah, and then oftentimes what that's almost inevitably what that's accompanied by is the adult child calling, on behalf, and I gotta have the client call me, and thanks for calling, but can you tell them? And it's like, well, she doesn't talk on the phone anymore.
Right. Yeah, right. So
Hands are tied.
Yeah, exactly.
So if possible, estate plan before.
Yes.
At that point, that way.
That's right.
Kevin, thank you very much for joining us today. This has been really informative. If someone has questions about estate planning, what's the best way to get in touch with you?
Oh yeah, thanks for asking. Yeah, I have a website, KTO as in Kevin Thomas O'Connor Law.com, KTOlaw.com, and my email is kevin@ktolaw.com.
Very nice. And you're based out of Santa Rosa, right?
Correct.
Yep.
Santa Rosa,
So your office up in Santa Rosa. So if you're local, he's local and very accessible that way. Well, thank you very much again for joining us today.
Thank you. Both.
Again, if you have any estate planning needs, I encourage you to reach out to Kevin. And thank you very much for joining us. If you like this content, please hit like and subscribe so you'll see future episodes. Thanks, everyone.
See you next time.
Welcome to the LivXplore Podcast. If you like what you hear, please hit like and subscribe.